We be prompt and just get underway? What do you think?
Let's do it.
All right. Welcome, everybody. My name's Chet Seward with the Colorado Society of Eye Physicians and Surgeons. We're so glad to have you at this special meeting this evening. Thanks for your participation, a little bit of patience. We're all virtual this evening rather than in person given the COVID pandemic. I sure hope everybody and your loved ones are well and weathering this storm. I'm going to run through a couple of things real quick in terms of the virtual meeting and how things work so we can make sure everything exceeds your expectations. And then we'll hand it off to our two wonderful panelists. If along the way you have questions, there are ways to interact with folks. And then we ask when you do that, just be kind and follow up with the muting back on again so that we don't have to hear the garbage disposal should you be doing dishes. Okay, so let's move forward with the presentation here. Already talking about welcomes and we'll go into interaction. So needless to say, tonight we're using Zoom. Zoom's a great platform, but I have to alert everybody on the call that while it's been a great platform, they have had some security issues. So if some unwelcomed strangers join us and start posting things or showing things on video that are inappropriate, I'm just telling you all right now, I'm closing it down. We'll have to reschedule, but you don't need to see anything bad, neither do I. And it's not worth any of our time. So we're gonna just close it down. Should something bad happen, giving you forewarning, we're gonna keep our fingers crossed that that's not gonna happen. With regard to Zoom, lots of really fun functions. First and foremost, everybody is automatically muted right now. You'll see in the bottom left-hand corner of your Zoom panel, kind of like this graphic here, the mute and the mute unmute button, and then the video button. You can turn your video on and off. Just be aware, if your video's on, your video's on. Don't forget, you would be shocked at what I've seen on some Zoom calls of late. Next, of course, is going to be how we're going to make this interactive. We're going to be using both the chat function, which is in your bottom panel here in that chat function. You'll get a pop-up bar right here, and you'll be able to you can toggle under the everyone to individual people or to everyone and just pose questions. It's a great way during live, as one of the panelists is presenting, that we can quick grab that question. I can unmute and surface that with them so they know what's going on. In addition to the mute, to the chat function, we're also going to have the Q&A later. And during Q&A, you'll be able to use the raise hand function right about here. And that will, when we're doing live Q&A, I'll be able to see hands raise up. I'll quick take notes who's up, and then we'll unmute you. And then you can have a nice live conversation with the panelists, and that will make it hopefully really interactive. Big picture, this is a piece of cake. Kick back, hopefully you're all in your jammies, but dressed up well in camera view. We're gonna have a great program. And in terms of great programs, we wouldn't be able to do that, first and foremost, without our #1 partner. And that's, of course, is OMIC. We are proud. CSEPS is proud to partner with OMIC. They stand up for the same values and the great care that you do. And it is just delightful to have them once again partnering with us on this presentation. I already went through the instructions. So let's drop into our panelists. We have two wonderful folks tonight. Greg Teimeier, I'll read from his bio real quick. I know many of you know him. He's been representing doctors, particularly ophthalmologists, for 34 years. Thank you, Greg. His experience in litigation includes almost 40 trials, half of which involved claims of negligence in eye surgery, almost all resulting in verdicts in the doctor's favor. Yes, you heard that right. He's a doctor's lawyer for sure. He's given dozens of lectures at AAO, ASCRS, and local ophthalmology meetings since 1993. Most of the presentations, like this one, have the goal of preventing malpractice lawsuits. So far, Greg's lectures have not accomplished this goal, and he is consequently still employed as a lawyer, but he's still trying. And today we're going to do one step further. Joining Greg is Dr. Ron Pelton, who is an oculofacial plastic surgeon and has been in practice in Colorado Springs since 2000. Dr. Pelton is a past president of CSEPS and currently serves as the chair of the Ethics Committee of the American Academy of Ophthalmology, as well as on the board of directors for OMIC. He's also on the board of trustees for AAO. Okay, enough talking for me. How about we turn things over to Greg and you take it away. Once again, Greg, just give me the heads up because I'm going to manually advance the slides and we'll have some fun here. Thanks.
All right, first slide. Before we get to the next slide, I just want to talk briefly. I was discussing this with Dr. Pelton and Mr. Seward before we got started, and I actually contacted Mr. Seward about doing this presentation because I had just finished up a couple of trials, one last February and one this last October, and in both of them, I and certainly my client, the doctor, were pretty convinced that but for the problems with the records, that may never have gone to trial. And because both of them had some pretty serious problems with them that made it difficult, but thankfully not impossible to defend them. We did get defense verdicts in both cases, but the fact is, and I've said this many times, if you've seen my presentations before, I recognize a lot of the names on here. And if you get sued, you've already lost because it's going to take a lot of your time. These trials, the first one took 1 week, the second one took about a week and a half. And just think about how much money you make every day and the fact that your overhead's still going on when you're not in the office, but sitting in the courtroom next to me. As much as I enjoy the trials, I can only think of one client that actually said he enjoyed it too. I appreciate the opportunities. I'm glad to be able to help my clients and friends, but it's not something that you really want to do. So let's go on with the next slide, Chet, and we'll get started here. This is the first case I had. As you can see, this was a 1-week trial, February of last year. And the claim was one of failing to diagnose a cytomegalovirus retinitis, which of course is quite rare. And the reason it wasn't diagnosed is because, well, I'm not quite ready for this second. There we go. Okay, back one more. There we go. Let's just stay there for a second. The patient that we went to trial on she was bilaterally blind, and that alone is kind of a difficult one. That's the second case I've taken to trial where the patient was bilaterally blind. But in this one, I was representing a corneal specialist. The patient had been referred to him by another doctor because of the severe dry eye that was preventing them from seeing the back of the eye, which is why the cytomegalovirus was not immediately diagnosed. The allegation by the plaintiff was that one of them was that the defendant should have done a lot more dilated exams or referred the patient to a retinal specialist who could do those exams. That alone was a rather interesting thing because the retinal doc said, well, I've known the defendant for years and I don't think I can see anything that he couldn't see, but nonetheless, that was one of the plaintiff's claims. Next slide, please, Chet. So, and I'm just going to take a moment to explain that in a failure to diagnose case, charting is more critical. Like, for example, in a surgical error case or a bad outcome from surgery, something like that, the records may be important, but they're not nearly as important as they are in a failure to diagnose case. Exam notes, what the doctor did, what the doctor didn't do, the tests and exams they ordered, the tests and exams they didn't order. All those things are critical. And of course, all those will appear only in the medical record. So the first exam by the doctor on referral was the slit lamp exam. We've got macula vessels and periphery in the fundus exam, dilated fundus exam, was all normal, which ordinarily would be good, except if we could go to the second slide now. The problem with that, of course, is that the doctor had been referred the patient because of severe dry eye, and the doctor was unable to see the back of the eye, and was, I'm not seeing a move on the slide here. I don't know if that's just me. Is it not clicking? Chad, any ideas what's going on?
Okay, so did advance what's going on here? So
next slide. There we go. Okay, now we're working. All right. The doctor's note for that same exam, where it said all of the retinal findings were normal, the doctor noted that he couldn't do a fundus exam because of the severe dry eye. The referring doctor had also said that he couldn't see the fundus due to the extreme dry eye. And so we have, from the very first entry in the doctor's chart, a undisputably unreliable entry. And so then let's go to the next slide. And these problems with charting didn't get much better. As I discussed before, the dilated examinations or alleged failure to do them was key to the case, and only one exam in 5 visits was actually documented. And the doctor explained in his deposition and in the trial that he did either attempt to examine the eye or actually do a dilated exam, but didn't note anything in the chart because he was unable to see the retina. And we'll get to the scribe issue here in a minute, but in one particular exam, they were able to reconstruct it. In fact, the dilated exam had occurred because of the medications that were given, the dilating drops were given. So obviously, you don't dilate a patient and not do an exam, although interestingly, the plaintiff's expert from New York said that he wouldn't be willing to accept that it actually took place just because they dilated them.
Hey, Greg. Greg, can I interrupt?
Yeah.
For some reason, your audio has gotten weird. And I'm not sure what's happened, but it's a very strange noise that it's making.
yeah, try muting and unmuting, Greg.
Okay.
Or reload altogether.
Okay. Sorry about that. Is this any better?
No.
No. Okay. So at this point, you're suggesting I should just close out and then come back.
Yeah, try that.
Okay. Sorry about that, guys. I actually tested this microphone before I started this. So I hope I can figure out how to get out of here. There we go.
Sorry, folks. Just hang tight. Greg will pop back on.
Sorry, battery.
Thanks for your patience. Thanks, everybody. He's going to be back in just a second. Got to hear him pop in here.
All right. Is that any better?
That's great.
Okay. Don't know what happened. All right, where are we? So anyhow, the dilated exams were key to the case, and most of them weren't charted, and we were able, as I said, able to reconstruct one of them. But even in that one, there was no context. There were just the abbreviations for the medications. There wasn't any description of what the exam revealed. And so as I said before, the expert from New York said he couldn't even acknowledge that that exam took place and was negative, which, you know, I thought was kind of silly, but I can see his point. Next slide, please, Chet. So the bottom line is that the things that could have kept us out of litigation and could have prevented the lawsuit from being filed, or if filed, from being pursued, were just not in the chart. There was only mention of one of the dilated examinations. There were, in most of the cases, no mention of the results of the dilated exams or attempts to dilate them, when the doctor would look in the eye and just determine, because of the appearance of the cornea. And the patient also had a cataract. That was why this whole thing started. The patient needed cataract surgery, but her cornea quickly developed severe dry eye. She had rheumatoid arthritis. I think it might have been related. But in any event, there was also no mention of the doctor's thought processes as to what he thought was going on or not going on. He believed a referral to retina was unnecessary, chiefly because prior to his referral, there was no evidence, and she did not report anything in her intake self-reporting of any problems that would suggest a retinal, some sort of retinal pathology. Okay, next slide, please. So in this case, the scribes, I think, I know the doc that was involved here is listening in, but it's my understanding that the scribe in this case was either fired or quit after this all occurred, of course, but before the lawsuit was filed. My personal belief, based on many years of having my own practice, is that most of the time when I fire someone, I probably should have fired them a month or two at least before I did. But nonetheless, the role of the scribes now is extremely important. When you're talking, they're trying to listen to you while looking at their laptop or the monitor in the room and looking at menus to put your message in, looking for pre-populated scripts that both best match what you're trying to say or to type in. And I'm sure you've seen many very, very awkward statements in the records that occur simply because you're trying to match a pre-populated description with what the doctor's actually saying. But all this comes down to you as the doctor signing off on the charts at the end of the day. And if you're like most, I would ask for a show of hands here if we were doing this live, but I would imagine most of you don't read through every single entry that was made for every single patient at the end of the day before signing off. It's extremely time consuming. I saw something in a medical publication recently that indicated that, based on a survey of many thousands of doctors, it was 18 minutes per patient to fill in the medical chart, which I think is just appalling, because of course that's time taking away from you being face-to-face and taking care of your patients. But in any event, given that fact, if we could go to the next slide, my message to you, if you do not have time to read through every single entry on every patient, and I know if Ann Menke was listening right now, should be staring daggers at me. But in any event, please, please, please check the outliers, check the unusual cases. I've had so many cases where the patient was an attorney. And actually, in a couple of them, I wasn't too surprised that they sued. I don't think they sued just because of that. I've also had a couple cases where the only reason they sued is because I think they were an attorney. Patients who've had a bad outcome. In a case like a fairly routine cataract case, and you end up with a bad outcome because of some unforeseen circumstance, or a LASIK procedure where, because the patient may have some basement membrane dystrophy that you didn't become aware of until the procedure was underway. Things like that, those are the ones you need to pay attention to. Those are the ones that are more likely to result in litigation, and consequently, those are the ones you need to be more careful with when you are going through the records at the end of the day. If you need to carry around a little pad or some sort of a reminder that you dictate into your phone, do it. But if you see some patient and you walk out of the room thinking, oh my God, what a pain in the butt, when you check through your charts at the end of the day, that's the patient you need to pay the most attention to. Patients who are unhappy with a bad outcome or with your staff. Patients who are unhappy with a good outcome. This next case I'm going to be discussing, the patient had a macula off retinal detachment about 5-6 months before the surgery that my client performed. And she still ended up with uncorrected vision after a cataract surgery of 2040, correcting to 2025, which I thought was astounding. And every single doctor, every treating doctor who testified agreed it was an incredibly good outcome. I mean, at one point she was corrected to 2020, and yet she was deeply unhappy with it. And my client said he was just astounded at how unhappy she was with what was objectively, by every indication, a very good outcome. And in that case also, that's what inspired my next entry, that the patient's spouse was very intrusive and unpleasant. He attended all the meetings and he did most of the talking. And this one is a little more difficult. When I first started doing these talks, 1995, what is that, 25 years ago? Yeah. Antidepressant and anti-anxiety meds are not as pervasive as they are now, but nonetheless, and Steve Schallhorn in San Diego actually did a study that pretty much showed what I've been telling people a long time, which is that if you've got patients who are depressed, they are more likely to be unhappy with an objectively good outcome. And I took that one step further, which is that they're also more likely to file a lawsuit from that. If we could have the next slide, please, now, Chet. And just so you know, the problems that you guys are having with EMRs are not lost on the plaintiff's attorneys out there. This back in 2015, when EMRs were still relatively new. And one of the questions, this is a direct quote from the deposition, and this was also a failure to diagnose case, is the information that you in this chart noted, in this chart note, typed by you, or was it populated by clicking a box? And I have another slide on a presentation I did on the same subject that I left out for purposes of brevity, but basically it was a note about a patient who was myopic, and it went into detail about, discussed the alternatives, including RK, LASIK, et cetera, patient understands, but the patient was 77 years old and had been wearing glasses for about 60 years. So my guess is that that conversation never occurred. This is another comment. This is my best estimate of what the best recollection the juror said after the trial. And even though we won the trial, they said there were so many inconsistencies between the records said due to the auto-populate functions and the auto-forward functions and what the doctor said she did, that it made her look very sloppy. So you got to be careful with these things, as I said before, is particularly in patients that may end up being problematic. If we could have the next slide, please, Chet. So this is case number 2. This is a case, cataract surgery case. I'm trying to think if it was anticipated. Yeah, she was a very high myope, so it was anticipated preoperatively that she wouldn't be necessarily a routine case, but what happened was not that much related to that. The problem was that after the cataract surgery, she had retained lens fragments. Those led to a prolonged intraocular pressure increases. And what she claimed to be glaucomatous damage, I don't think she had it, although they were able to find an expert from Burbank, California, who said, pointing to one very unusual thing on the OCTs, saying that she did. But the focus of the trial was whether the doctor was aware of the retained lens fragments. And part of that was because the doctor never actually, although he would write down, lens fragments observed, it didn't say, and I think, by the way, these are causing the increased intraocular pressure. He did come fairly close to that, where he did say that a patient has increased intraocular pressure, question due to steroid response or retained lens fragments. Again, I think the plaintiffs were reaching a bit on that one, but nonetheless, that's the hand we were dealt, and that's the hand we played at trial. So consequently, any chart entry pertaining to the location of the lens, whether it was in the anterior chamber or in the posterior chamber, the nature, whether they were nuclear fragments or cortex fragments, and the size of the fragments were all pertinent to the case. And all these issues were discussed by the plaintiff's expert witnesses and consequently by the defendant and his expert witnesses. Next slide, please. And so here we have one of the assessments. This is the initial exam. All very straightforward. I think probably most of it was auto-populated too. I've seen this language before, I'm sure you have. And then 3 days later, the cataract surgery is done. This wasn't his first exam. He didn't do the surgery 3 days afterwards, but this was the last preoperative exam. So for the cataract surgery, it was done in an ASC, and a form was used, as most cataract, I think every cataract surgery case I've seen has. No aberrations or complications were noted. Specifically, it was noted that the nucleus was removed using the phaco handpiece, followed by aspiration of the remaining cortex. As we discovered, that of course was not true. And being fair to the doctor, of course, you can't always see it in the middle of the surgery, but the doctor knew this during the procedure, which is why, you can go to the next slide now, which is why after the surgery, he did a handwritten note, not all of it handwritten, but basically interlineating into the pre-printed chart note, all the problems that occurred. What happened during the procedure is the patient started getting a little bit light on the anesthesia, the local anesthesia, started getting uncomfortable, complaining of the pain, and to make it even more exciting for the doctor, she experienced premature meiosis. And so the doctor was having to pull the iris back. So as he's trying to suction out the remaining cortex, and then with the patient complaining the whole time, finally he just thought, we got to get her out of here, or something really bad's going to happen. And I imagine many of you have been in the same situation before. And, kudos to him. He did write all this stuff down in a note. The problem was that note was lost, and it became the focal point of the lawsuit. I mean, seriously, it's like almost the entire lawsuit was a discussion over what happened to this note. Most of the opening statement, most of the closing argument, all that was what the plaintiff was talking about. And as I said before, she had a great outcome. That's probably why they were talking about the lost note. Nonetheless, the plaintiffs were implying that there was something really nefarious going on here, that there was some really bad language in this operative note. And that was the reason that it was suddenly mysteriously evaporated. And they actually filed a motion with the court asking that the doctor be sanctioned for destroying evidence. The court ultimately denied that motion, basically let the evidence come out during the trial, let us deal with it, and then decided at the end of the trial that there would be no sanctions. And then I talked to the jurors afterwards, as I usually do. And this was like a 4 or 5 hour verdict. I think on the last day, all we did was closing arguments in the morning, and then we adjourned for the day, and the jury went to deliberate. And we didn't get the verdict until like 5, 6 o'clock in the evening. And if you think if you think waiting in line at the DMV makes time crawl, you should be waiting for a jury. That might as well have been a week. And the jurors, when I talked to them afterwards, said they spent most of the time arguing over what happened to the op note. And there were two camps, one who thought it was probably just like the doctor said, and the other camp was just like what the plaintiff said. Interesting thing is they all decided the care was appropriate, but they spent probably 2 or 3 hours talking about what was in the note, why it disappeared, and all those kinds of things. So save yourself a lot of grief. Just be real careful if you have to write. If something weird happens, remember going back to my earlier one, you've got to be careful with the documentation and the outliers. You've got to. Those are the ones that I end up seeing. Next slide, please. So after this surgery, the patient ended up not only with retained lens fragments, but also a subluxed intraocular lens. The doctor had a discussion with the patient, and this is the notation. This is, of course, a post-operative exam. I think it was about 3 days post-op. Risks and benefits of both options explained to the patient in detail. The chart, however, did not discuss which options were explained to the patient in detail. Patient elects to have I know what they were, you know what they were, but nonetheless, the patient decided to have the exchange. Risks and benefits of the procedures, all questions have been answered. Next day, IO was removed and replaced due to the subluxation. Next slide, please, Chet. And so post-op exam, day 1, very next day. And this is what we have under the plan. It may look familiar because it is auto-forwarded from the preoperative examinations 2 days previous. And the note is made to return to the clinic on Friday, August 5th, 2 days later, for an intraocular pressure check, because he knew at that time and had noted in the chart that there were retained lens fragments. But nonetheless, again, the jury's looking at this and say, well, how can I rely on this? That we've got this notation about risks and benefits, and the surgery's already taken place. So then let's go to the next examination on, I think it was August 5th. Next slide, please. Yep, second post-op exam, 2 days later. The doctor's really watching this patient. That's one of the things that the jurors commented and gave him kudos for, was that he was very, very attentive to her complications. But the EMR has the same damn entry again. And it even has the entry about returning to the clinic on Friday, which is, of course, that day. And you can't really return to a clinic if you're already there. And we are still having informed consent discussions for a surgery that occurred 4 days previous. Next slide, please. And at the third exam, it doesn't get any better. This doctor is being, ostensibly so extremely thorough that he is having discussions of informed consent over and over again, even after the surgery has occurred. At least they did take out the return to the clinic on 4 days earlier. Now, at this point, you may be thinking, God, Greg, give this guy a break. I mean, none of this had anything to do with the patient. It had nothing to do with their outcome. You make mistakes too. Everybody makes mistakes. Aren't you being a little harsh here? Yeah, I probably am. But you know what? I have not had, in the last 5 years, any trial where errors in the EMR did not become an issue in the case. And as I said, what spurred the conversation we're having now is that the last 2 trials, I think that was probably the main reason we ended up in the trial, not the medical care. And so, although I'm being a little hard on these entries, I'm not being hard on the doctor, because if we go to the next slide, please, this really had more to do with his technician, who also was, I can't remember if he was fired or quit, but basically for the problems that you're going through now. The guy just was not attentive to making correct entries in the chart. Now, of course, the doctor's responsible for that. He signed off on every single one of these entries, which is why I'm telling you now, if you've got weird patients, if you've got unhappy patients, if you've got weird outcomes, really, 2 standard deviations from the mean, you need to be more careful about reviewing those charts. So remember what I said earlier about, with that earlier slide about documenting and monitoring retained lens fragments. This is what we've got. So here we're August 15, we're 2 weeks out from the re-operation to put in a new IOL. And we've got a great note here: mild cortex remaining in vitreous, but improvement upon the slit lamp examination. And as you can see, there are patients on maximum topical oral medications, IOPs at 28. Good note, very helpful to our case. Everything's fine. And I love this kind of note. Let's go to the next slide, please. The problem occurs when a week later, we have the same damn note, including an IOP of 28. I didn't put the whole chart note in here, but the IOP was not 28 on this day, it was 42. And so the note of mild cortex remaining in the vitreous, but improvement on slit lamp examination, is probably not going to convince anyone that that was actually what was happening, because all of this was simply auto-forwarded from the previous examination. And again, am I being a little hard on this? Yeah, I am. But that's the whole purpose of this, is that you need to be aware of the consequences of not being careful with these difficult cases and how they can end up with you talking to the jury about them in trial. And I don't know that any of you would want to explain to a jury why you signed off on a note where the intraocular pressure was clearly incorrect, while the vitreous cortex remaining, or the mild cortex remaining in the vitreous, is exactly the same language as the previous one, and why should I believe you? Next slide, please. So, and then this one just bugged me, and I'm putting it in here again. It doesn't really have anything to do with the outcome of the patient, But aside from the gray spot, that was also an issue of what her complaint was. But this is direct quote: patient complained of blurred vision, occasional pain, gray spot in the visual acuity. Quote, relief is experienced from going away slowly. Now, we all know what happened, because relief is experienced from, and then you're supposed to click on a box or type something in, and they typed in or clicked on a box that said going away slowly. But let's say you're on the witness stand and you got 6 people who are going to decide whether you did the right thing in this case or not. And they ask you, doctor, what does this mean? What the hell are you going to say? It doesn't make any sense whatsoever. And so again, your chart, especially in a failure to diagnose case, is the holy grail. This is the thing that the jury is going to have to rely on, because they know you can't remember every single thing that happened with every single visit of this patient, along with the other 40 or 30 that you saw that day. So this, just don't put yourself in that situation. Let's go on to the next slide, please. So I'm not totally down on EMRs, although I got to say the best one I ever saw was one that a doctor created on his own, hired a programmer, and it was wonderful. But unfortunately, that's not what you guys have to work with. You've got autofill, auto forward. I've heard, I don't know, maybe some of you guys can comment on this, that the FDA wants to take away the autofill, auto forward functions. I know that won't be really popular with the docs who are already spending 18 minutes per patient on the damn EMR, but it leads to problems like I've just been discussing for the last half hour. It also decreases the connection that you have with the patient. And I will tell you from my experience that the better the personal connection you have with the patient, the less likely that patient is to sue you. There are studies that will back up that comment. Also, and this is more of a problem for me, although it has been a problem for you, is that when you print out the file and give it to me, depending on what format you do it under, what type of a report you're asking for, or the person who's doing it for you is asking for, it may or may not include all the information. And I had a case with a doc once, about 5 years ago, and he found, I think it was like, I want to say a week before the trial, that the report that had been provided to me from his office was incomplete, and there were several entries that were not included that were actually quite beneficial to the case. At that point, because it's so late in the game, the judge wouldn't let him in. We ended up winning anyway, but just be aware that when you give this task to someone in your office, you may want to, if this is a lawsuit, you may want to look it over yourself and compare it to the electronic, what's printed with what you're looking at on the screen, and make sure that you're getting all the data there. And then also, as we discussed earlier in case number 2, with the missing operative report, what's going on with your paper data? Is it getting scanned in? Is it getting entered into the patient chart properly? So these are all some of the issues with EHRs or EMRs. Next slide, please, Chet. And then another thing that I like is that I can read everything that's in the chart now. It may not make a lot of sense, but at least I can read it. The bigger problem, in my opinion, just after seeing these over and over again, is that the chart is full of irrelevant documentation. It takes me so long now to go through a record. And if it takes me this time, I know it takes the doctor and staff a lot of time. You may not catch errors that otherwise would be apparent if there was less verbiage to wade through. And although you may think, well, that's not pertinent to what's going on with the patient, when it comes to trial, the plaintiff's attorney will try and make a big deal out of it, and the jury may too. I say usually the juries understand what's important and what's not, though. In the end, though, you've got a chart that's got lots and lots of repetitive statements, formulaic statements, things about the patient's history that have nothing to do with what you're doing, physical examinations, all this stuff. And it's just a whole lot of chaff with not a whole lot of wheat in there. Next slide, please. And so the jury is left to look at all this stuff with both sides saying, because I always ask experts when I take their deposition, well, you have errors in your EMRs too, don't you? We probably couldn't pick out a chart that didn't have an EMR error in it. And they always agree because it's true. But what's the jury left to see? So all you docs are using these records that have nothing that you can really rely on. That's not really a great way to, I think, impress people. And I know this isn't your fault, but there are things that you can do, and we've gone through some of them, the chief one being if you've got odd patients, angry patients, bad outcomes, good outcomes with an unhappy patient. Please, please be more careful with those. If we could have the next slide, please, Chet. So like all technology, and I don't know if you noticed in the earlier slide, I had EHR. I had to go through the first presentation of this one because every single time the computer would autocorrect it to HER. Sometimes it's helpful, sometimes it's not. It can allow you to send information to other doctors, doctors that are also treating the patient, to the referring optometrist or ophthalmologist with a click of a button, and all that's great. But you need to train your staff carefully about how to enter and retrieve the data. Especially if you've got new scribes, you need to go through every chart for a week or two, sit down with him or her and say, okay, look, you wrote this, but what you should have written is this. You failed to note this comment by me, which is actually crucial to this patient's diagnosis. So be really careful, especially with new people until you've reached a level of trust. Be very careful, very attentive, so that you can make sure that you're getting the right data and the right information into the patient chart. Next slide, please. So this is my own not very clever comment, but I think it's a good rule of thumb. When the going gets weird, the smart check the chart. And I don't care what's making it weird. I don't care whether it's an angry patient. I don't care whether it's and this is not made up. This is a case I had an attorney who was a -12 getting LASIK, and of course ended up with microstriae afterwards. She was a bond lawyer. She spends all day reading 8-point type, so you can imagine how that went over with her. And in that entry, in that chart, the doctor had maybe 5 sentences in 8 postoperative exams, and that's what got him into hot water. And he was a smart guy, but you've got to recognize that when you've got unusual situations, when you've got unusual angry patients, you need to pay particular attention to those people and be very careful with their charts. So that's about all I've got now. If we've got any questions, I'm happy to entertain them. I suppose I should click on the chat box now to see if we've got anything.
No chats thus far.
Okay. Cool. If anybody has anything, you just type it into the chat. I guess that's how we're doing it. Chat, is that correct?
You can answer them on the fly, Greg, if you'd like. And right now, just for being sensitive to time, I'll turn over to Dr. Pelton, please.
Sounds good. Thanks, guys.
All right. Thank you, Chet. Thank you, Greg. So I'm just going to basically pick up where Greg left off. Next slide. As Chet said, I am on the board of directors for OMIC. So one of the things I want to talk about is some of the common deficiencies that we find in that lead to lawsuits and that make lawsuits difficult to defend. So next slide. So when OMIC finally wraps up a case, and the claim is closed, we ask the defendant doctor a couple of questions. The first question is, what sort of risk management issues were brought to your attention by this claim? The second question we ask is, since this has happened to you, what steps have you taken to reduce exposure to this sort of thing in the future? Next slide. Interestingly, half of the responses to the first question and about 1/3 of the responses to the second question have to do with documentation problems that the insured ophthalmologist felt impacted that claim. Next slide. So, as you might expect in a surgical subspecialty, one of the things that the plaintiff's lawyers that get involved in these cases look at is the operative report. So documentation deficiencies in operative reports are one of the more common areas where we have issues. So the majority of OMIC claims are made against cataract surgeons. That kind of makes sense. Most of us do a lot of cataract surgery. The most common documentation deficiency has to do with lack of documentation of posterior capsular rupture. Now, we all know that this is a known complication of cataract surgery. And if it is documented in the operative report, if it's disclosed to the patient, and if it's managed well, in any lawsuit involving this, your defense attorney is going to claim that this is maloccurrence and not malpractice. However, if you don't note it in your operative report and explain what happened, and if you don't disclose it to the patient, that's going to be a very, very difficult case to try to defend. Next slide. So we had a case, for example, where a patient underwent cataract surgery. There was rupture of the posterior capsule, and a lawsuit was filed. Now, one of the things that we do in this situation, OMIC will then find another expert, for example, another cataract surgeon, who will look over the medical records to help us find a strategy to defend this case. And in this particular case, the surgeon had used a pre-dictated operative report and didn't go back and amend it or make any changes to explain the complication, how it happened, and what he did about it. That made the case very difficult to defend, and we ended up settling that case for $200,000. We had another case in which a claim was filed against a LASIK surgeon. The problem in this particular case was that there wasn't any operative report. Turns out this LASIK surgeon said that unless there was a complication, he never dictated an operative report. And in this particular case, he didn't think there was a complication, and the patient did. So once again, if there's no operative report at all, that's going to be a very difficult case to try and defend. The last one I'm going to talk about is a case in which the surgeon dictated not one operative report, but two operative reports. Now, the problem is he dictated two reports on different days. He gave two different explanations of how the complication happened and what he did about it. And when this came to light in the lawsuit, it again made the case very difficult to defend. Next slide. So the take-home message here is, number one, dictate an operative report, and preferably dictate the operative report as soon as possible after the surgery when it's still fresh on your memory. Number two, be very careful with these pre-dictated reports. And if there is a complication, make sure that you go back and amend the report and explain the complication. Number three, be sure to document any complication. Make sure that you give your explanation of what happened and then what you did about it. And of course, last thing to do is to make sure that you disclose any complication to the patient and to the family. I recently dealt with a case in which several months went by before the surgeon disclosed the complication. And of course, that's a case that's going to be very, very difficult to defend. Next slide. Well, we don't have our sound on this. If you go onto YouTube and type in plaintiff's attorney operative report, you're going to find attorneys such as this one who troll the internet looking for clients who will use an operative report against you in a lawsuit. So it's very simple. You just go to YouTube, look for these guys, and you'll find lots of them. And it's pretty scary what their take on this is. But again, this is the kind of guy who's going to use that lawsuit, use that operative report against you in a lawsuit. Next slide. So then the next type of document deficiency that we run into has to do with your preoperative decision making. So these plaintiffs' attorneys realize that if there is no surgery, there's no complication. So one of the reasons they're going to look, one of the things they're going to look for is they're going to pour through your medical records looking for your decision-making process. They're going to try to figure out why you decided to do what you did. One of the things they're looking for is to find out if the surgery was actually indicated. So we've had a number of lawsuits in this area. Next slide. Back up one. So this was a case in which we had a surgeon who took off a benign lesion from a patient. The patient afterwards developed double vision and excessive scarring. And so we hired a defense expert, another surgeon, to look at the case. And one of his criticisms of the surgeon was that there was absolutely no explanation whatsoever in his preoperative assessment of why he wanted to take off this benign lesion. There was nothing in there. There was no complaint from the patient. There was nothing in there that suggested this might be a malignancy. So without any documentation of why he was trying to do this, that was a case that was very difficult to defend. So that case ended up settling for $95,000. Next slide. So this is another case. This patient underwent surgery and then developed irregular astigmatism after the surgeon put in a premium toric IOL. Once again, we hired a defense expert, another cataract surgeon, to go and look at the medical record and help us find a way to defend this. He was very critical of the surgeon because in the preoperative assessment, there wasn't anything about keratometry, about topography, or any sort of refraction that would help the surgeon assess how much and where the astigmatism was. It would have also been, of course, very helpful in trying to defend this case. So once again, this is a case that we had to settle. Next slide. So the take-home message from this is don't just document what you're doing, but also document why you're doing it. And if you do, unfortunately, end up in a lawsuit, this will be very helpful in helping the jury to understand what you were trying to accomplish. Next slide. So the next thing we're going to talk about is informed consent and some of the deficiencies that we see in the informed consent process. This is one of the most frequently challenged things by plaintiffs' attorneys. Next slide. So it's always difficult, more difficult, to get informed consent when the patient doesn't speak your language. This particular case involved a gentleman who spoke only Spanish and the surgeon didn't speak any Spanish. Ultimately, the patient underwent cataract surgery and had a complication that led to retinal detachment and loss of all of his vision. And of course, this ended up in a lawsuit. Once again, the defense expert that was reviewing the chart criticized the surgeon because there was no consent form in the chart. There was, in fact, there was nothing about informed consent. For example, he didn't say anything about translation or who might have done any sort of translation for him to the patient. And that case, we ended up having to settle for $200,000. Next slide. So when you do informed consent, you need to document, especially in these limited English patients, what language the consent was done in, and the name and relationship of any of the translators. Was it a family member or was it a professional translator? Once again, this becomes very, very helpful in a lawsuit that involves a patient who doesn't speak English. Next slide. So the take-home message here in this area is, number one, the surgeon has to be the one doing the informed consent. Now, that doesn't mean that you can't get assistance to help you. For example, your assistant can have the patient sign the informed consent paperwork, but the surgeon has to be the one explaining the risk, benefits, and alternatives of the process. Number two, OMIC strongly encourages you to use procedure-specific consents, and that you get these consents taken care of before the day of surgery, not on the day of surgery. The good thing about that is you can give the patient a copy of the consent to take home with them. And then later on, it would make it very difficult for them to make any sort of claim that they didn't have time to think about it, or they didn't have time to read over it and understand the consent, or they didn't have time to formulate questions about the consent. So if you do it before the day of surgery, you can give them a copy of the consent so they can read it themselves. Number three, we, of course, encourage you to do the consent in the patient's native language, if at all possible. And number four, go back and revisit the consent on the day of surgery. Just pull it out and just ask the patient, were there any questions that came up since you last signed this? Are there any questions that you haven't had answered? And once again, that always works in your favor should you end up in a lawsuit. Next slide.
Did you know that if a doctor didn't give you full information in order for you to make an educated decision about what type of treatment you needed, you may have a claim for lack of informed consent? Would you like to learn what that is? Come join me and I'll tell you.
This is another one of those that I found on YouTube. I can promise you that the plaintiff's attorneys understand informed consent. And if it's not done properly, they will use it against you. Next slide. Now, if you go to the OMIC website, you can find consents in Spanish. You can also find recommendations for the use of other non-English speaking and for deaf patients on our website. Next slide. I'll also point out that if you go to the OMIC website, you can find a large number of procedure-specific informed consents that you're welcome to download and personalize for your practice. You don't have to be an OMIC insured to do this. Anybody can go to the website and download these consents. So I encourage you to go and look on that website and look at all the different ones that are available. Next slide. The next area I'm going to talk about has to do with examinations and testing, because we've had quite a few lawsuits that would have been defensible if the key exam elements had been documented in the medical record. Next slide. Interestingly, the most frequent failure to document with general exams has to do with dilated retinal exams in patients that later on developed retinal detachments. We had a case not long ago where the ophthalmologist actually stated that he did the retinal exam, but there was no documentation of this. So, of course, that was a very difficult case, and we ended up settling that for $100,000. We had another case where the patient developed a retinal detachment, and the surgeon stated that he actually did a dilated retinal exam and documented it. But during his deposition, the plaintiff's attorney asked him why the documentation was done in two different colors of ink. And at that point, he confessed that he went back and added to the medical record after he found out about the retinal detachment. Again, that's a case you're not going to win. We settled that case for a little over $300,000. We had another case in which an ophthalmologist was asked by a colleague to take a quick look, and the ophthalmologist was asked if she thought this was a retinal detachment. And she looked in the eye and said, "Yep, I think that is a retinal detachment. This patient needs to see a retinal surgeon. And later on, the patient ended up losing vision in the eye, and he sued everybody that was involved, including the doctor who did this, this quick examination. Now, she considered this to be just a curbside consultation, so she didn't document anything, and that worked against her. So just remember that anytime you examine a patient, you have established a physician-patient relationship, and you need to document anything you do with that patient. Next slide. So the take-home message here, document, document, document. Number 2, make sure that once the claim has been filed, that you lock away the chart and you don't alter the record. And number 3, if it hasn't been made clear to you, make sure you document. Next slide. The next area I'm going to talk about has to do with telephone consultations. So all of us take after-hours calls from our patients, from our colleagues' patients, and from the emergency room when we're on call. And that's an area that people frequently fall short with documentation. Next slide. We have regularly had to settle lawsuits because these telephone consultations weren't documented. Next slide. We had a case, for example, where a LASIK surgeon did surgery on a patient, and a few days later, the patient called the doctor and said, my eye is red and painful. And he said, well, just use the artificial tears that I gave you. It's probably dryness. A few days later, she called back again. This time she was out of the state and said, my eye is getting worse. He said, according to her, he told her to just keep using the artificial tears. At his deposition, he said that he actually told her to go to the local ER, but none of this was documented. So of course, we didn't stand much of a chance to win that case, and that's one that we ended up having to settle. Next slide. Once again, the take home here is very simple. Make sure you document. Number 2, again, make sure that once the case has been filed, that you don't alter the record. And number 3, make sure you document. Next slide. And I want to point out that if you go to the OMIC website, we have forms on there to use for these sort of after-hours telephone consultations. Next slide. So this is the last area of deficiency I'm going to talk about, and it goes pretty much hand in glove with everything that Greg said during his presentation. And that has to do with electronic medical records and these auto-populate functions. Next slide. So we had a case in which a young child was taken to the emergency room by her mother. While in the emergency room, the ER doc found the child to have a non-reactive pupil. There was a small laceration in the conjunctiva, and there was a traumatic hyphema. So he called the ophthalmologist on call. The ophthalmologist on call said, have the patient come see me tomorrow. And so the next day, the mother took the child to see this ophthalmologist. He examined the child and filled out the medical record and then said, come back and see me in a couple of days. Unfortunately, the very next day, the child started losing vision, so the mother took the child back to the emergency room, and the child was referred to a new on-call ophthalmologist. And this ophthalmologist found out that the child had sickle cell. At this point, the child had no light perception vision. The pupil was fixed and dilated. The pressure was 46, and of course, she had a 4+ APD. This, of course, ended up in a lawsuit, and during his deposition, the first ophthalmologist that saw the patient was horrified to find out that his medical record had auto-populated everything as normal. He said that he had intended to go back and change all of this, but he forgot, and so he never did. Of course, that's another case you don't have a chance of winning. So that settled for $380,000. Next slide. This is the last case I'm going to talk about. In this particular case, we had a gentleman who was a diabetic with hypertension. He ended up developing a retinal detachment and vitreous hemorrhage, and he went to the operating room for a pars plana vitrectomy and a FS6 injection. A few days after his surgery, he went back to the surgeon in pain and was found to have a pressure of 37. So the surgeon did a tap to lower the pressure, but he never recorded any of the pressures after that. Next slide. A few days later, when the patient ended up back in the office, the patient was now no light perception in the operated eye. And even though he was no light perception, the surgeon's medical record said that the patient had pupils that were equally round and reactive to light with no APD, that the patient had full confrontational fields. Next slide. And his assessment that even though the patient was now no light perception, he was doing well after his surgery. Obviously, the medical record had auto-populated all of this. And again, this is a case that we can't defend. Next slide. Our expert that reviewed this case gave this quote: beyond issues of questionable management of the IOP, there are many issues with documentation. Most of the exam findings were noted as normal on all visits, even post-op when the right eye becomes Tysical. Poor IOP management and documentation issues make the case very challenging to defend, and that's pretty obvious. Next slide. Once again, document, document, document. You need to be very, very careful with this auto-populate function. And I think Greg's cases were a great demonstration of that. And number 3, go back and check your medical record, as he said, especially if you have a scribe. Make sure you know what they're putting in there. Next slide. And I'll leave you with this quote that we all learned when we were medical students, that if you didn't document it, you didn't do it. So tuck that away. Next slide. That's the end of my presentation. So Greg and I think we'll both take questions now.
Great.
Actually, this is Greg. Could I make a chat? Do you mind if I take about 5 minutes to make some follow-up comments on some of the points, really good points that Ron brought up? Sound good? Okay. Just going in order of his presentation, I just made some notes here. On the if you have an intraoperative complication, as Ron said, you need to document it. Also document, after you've had the conversation with the patient, document that you had a conversation with the patient about the complication. Can't tell you the number of times where I've had patients say, well, the doctor never told me anything went wrong. And I found it hard to believe, but nonetheless, document not just the complication, but the fact that you told the patient about it. Next point, on the Spanish language, informed consent. As Ron pointed out, OMIC has on their website the informed consent in Spanish. I don't know if do you have other languages too, Ron? Do you remember?
I don't think so.
No? Okay.
It's just Spanish.
In any event, if you're doing cataract surgery, that's not an emergency. If you're doing an emergency surgery and you have problems with informed consent, I remember I was in Germany where I had my appendix out. I was on vacation and I didn't understand a word the doctor told me. But it was an emergency. It was a burst appendix, so it didn't matter. But cataract surgery, I don't know, maybe you guys can think of an instance in which it's an emergency, but that's not getting a proper, correct language, informed consent, or some sort of documentation that the patient was informed through an interpreter. You're not going to come out good on that one if you've got a bad outcome. And then as to the issue of the informed consent, I've always liked the idea of giving it to the patient, letting him take it home. I know some doctors don't like to do it because of patient flow issues. Nonetheless, I can tell you as an attorney, I love it if they do that, because it is so hard for any patient to say, and I've had them try on cross-examination that, well, they didn't give me time to read it, or I took it home, but I didn't read it. It's like jurors will not buy that. But if they sign it before you as the surgeon have had a conversation with them, even if it's just to ask them, do you have any questions for me about what you read on the consent form? And then just a brief discussion of the most common risks, you know, overcorrection, undercorrection, loss of the eye, loss of vision, that type of thing. Have them re-sign it. Because I remember my very first trial many, many years ago when my hair wasn't this gray, the jurors came back against the doctor on the only issue of informed consent, not against negligence, just informed consent, because the informed consent form was signed before the doctor talked to the patient. Kind of makes sense, actually. On the issue of the curbside consult for the retinal detachment, it's funny that you mentioned that, Ron. I actually have a case going on right now where exactly the same thing happened. A general ophthalmologist has a retinal specialist across the hallway, says, hey, can you take a look at this guy? Retinal specialist takes a look at the guy, finds nothing wrong. 5 months later, he's got a retinal detachment. I don't think they're related, but of course, nothing's in the chart. And so now the retinal specialist is on the receiving end of an unpleasant lawsuit. Plaintiff in that case is also an attorney, by the way. And then two last points. I just have to say the slides that Ron put up that were similar to mine about, you know, the patient's blind, but their pupils are equal and reactive to light, and they've got CVF full and normal. That's not uncommon. I see that all the time. So you just, again, just as Ron said several times, document, document, document. I'm telling you, be careful of auto-populate. And then finally, I know, Ron, you've got to say that if you didn't document it, you didn't do it. But if you ever get in court, please, please, please don't say that as your attorney. It just makes, it's like nails on a chalkboard to me. And so anyhow, that's all I've got. Thanks, Ron. I really appreciated it and enjoyed your presentation.
Well, thank you. So Dr. Lewis has a question that he wrote in the chat. Where does OMIC stand on the use of Optos for documentation of the retinal exam? I don't think OMIC has a stance on the use of Optos for documentation of the retinal exam. What I would suppose is that if you take a picture of the retina, that's obviously good, but you also need to interpret that for real documentation, because just taking a picture of something doesn't know or doesn't document that you actually know what you're looking at or that you have an opinion about it. If you do an Optos and you find a retinal detachment, but you don't mention anything about it in your documentation, that's probably not going to work in your favor. In fact, it would probably work against you, because the plaintiff's attorney would say, oh, so you saw it, but you didn't do anything about it. So if you're going to use the Optos to document the retinal exam, make sure you do an interpretation.
I know there are a couple of folks from OMIC on the call. Anybody want to add to that at all? You can just unmute.
Fonte, Dr. Fonte, any comments?
Hi, Ron. It's Michelle, risk manager at OMIC, and I was just curious. So for the Optos, it's a charge, right? You charge for that. There's a fee.
Well, we only charge in the event that we find something wrong. If you don't find anything wrong, then there is no charge.
Got it. Okay. Yeah, I would agree with Dr. Pelton in terms of it's you know, we don't have an opinion one way or another, but do please comment about what you think that picture says. Otherwise, you know, what's
well, I think that goes without saying, actually. I mean, if you're going to take the picture to demonstrate something, you want to point out what you're looking at. So.
Great. We have another question here from one of my colleagues here in Colorado Springs. Do you need to document that you disclosed a broken bag / surgical complication with the patient, or is verbal disclosure enough?
Can I take that one, Ron?
Yeah, I was going to say, I think that's probably a good one for you.
Yeah, it's kind of like what I just said. That's a very good question, and you know, in a better world, I think just telling the patient would be enough. But in the world we have, where you've seen, I wasn't even aware of the attorneys trolling on YouTube that Ron got. Those are amazing, but makes me feel really inadequate here. But yeah, document it. Because like I said, I have had many cases where there's complications that I just know from working with doctors, they of course would discuss it with the patient. And they have to, because the patient comes back and they have to address the complication. But the patient always says, well, the doctor never told me I had this. So yes, you do have to document it.
Any other questions?
I see we've got that comment. I don't know if you see it, Ron. Optos is not a substitute for scleral depression, DFE, is what I believe most retinal specialists would say. And I was just thinking, I was having a conversation earlier today with an ophthalmologist about using photographs to document things, or actually he was talking about telemedicine, using it to diagnose. And my concern was the lack of, you know, evaluating, for example, cup to disc ratio with lack of stereoscopic vision. But anyway, I think that's probably better for you to talk about, Ron.
Well, first of all, I don't have an optos. I'm an oculoplastic surgeon, so I don't do most of that. And I know we've had this discussion before on the ethics committee concerning scleral depression. And are you, as a comprehensive ophthalmologist, going to be held to the same standard as a retina specialist? There's differing opinions on that, but I think most people would agree that the optos is not sort of a perfect substitute for dilated fundus exam. And I think I would be more concerned about not what I see, but what I don't see. So just something to keep in mind, that optos can help you document things with a picture, but it's probably not going to be a substitute. And I can tell you this, one of the things that we've seen at OMIC many times is the plaintiff's attorneys will almost always be able to find some expert to say that whatever you did was not up to par. So just know that if, as Greg said, just by virtue of the fact that you've been named in a lawsuit, you've already lost. Not only are you going to lose that week in the sitting in court, you're going to lose 2 or 3 years leading up to that, and lots of sleepless nights. So do everything you can to document everything you see, and that will go a long way toward keeping you out of that. And I think Greg also made a very good point, which is it's a lot easier to stay out of court than to defend yourself once you end up there. So the cases that he presented probably should have, as he said, never should have gone to court, and wouldn't have maybe if the documentation had been better.
Other questions from the group, you can enter them into the chat or just unmute yourself and jump in.
Hi, it's Michelle at OMIC, and I just have a quick question for Greg, because I speak a lot at meetings about this topic. And what percentage do you actually think is like system error versus user error, and how much does training go into that?
That's a great question, Michelle. And I assume by system error, you're talking about someone other than the doctor has made an error with the medical record?
Or the EMR system isn't necessarily for ophthalmologists. So it's a system for all doctors, and it pre-populates and does things that don't necessarily work for an ophthalmologist.
Like Epic.
Correct.
Yeah, I don't know that I've had a case with a non-ophthalmologic EMR yet. I can see, first of all, that would be, if I was the plaintiff's attorney, I would be asking questions about why are you using a system that's not designed for ophthalmology, and raise that as a standard of care question. I would imagine that I could think of 3 expert witnesses off the top of my head that would say that was below the standard of care, because they're all plaintiff's experts, and as was pointed out before, you can get people to say any number of things. I think, Michelle, the more important point you raised is how important is training. And I hit on that in my discussion, and I'll do it again now. EMRs are not worth anything if you are not well trained and your staff is not well trained to use them, particularly your scribes. They are the critical juncture between the EMR and what it is you are seeing and saying. And that is, you just get some good people and train them well. I always like to tell people about a study that was done at the Harvard Business School that looking at I think it was 100 top companies in the United States, and the thing that differentiated their appreciation and stock value was training. That alone, more than anything else. So training's good. Use it.
Hey, Greg and Ron, it's Jim Conahan. Thanks for a great presentation. I just have one quick question. As somebody who's not enamored with EMR and never have been, I tend to do a little bit of both sometimes. Can you submit chart handwritten notes along with EMR notes in litigation?
You want me to take that, Ron?
Yeah, I've never seen that. Go ahead.
I've seen mixes, Jim, and I see nothing wrong with it. You know, sign them, date them, don't use different ink. If your pen runs out and you start writing with another pen, note that you were writing with another color of ink. Now, Ron mentioned that, and I've seen it before too. But the better thing to do would be to take your, and I certainly understand your lack of infatuation with EMRs, but a better thing would, because I believe almost all, if not all EMRs have a scan function, and you can scan it, and that way it's date coded. So there's no question of you, after the fact, conjuring up some records to supplement your EMR with, because your EMR on itself does not look very good. And I understand that may not be exactly what you'd like, but that would be my recommendation. So number one, it's better to document than non-document. Number two, it's better to get that document into your EMR where it's date and time stamped and can't be altered.
Okay,
Make sense?
Yes.
You bet.
No, full disclosure, I should point out, I don't have an EMR. I never have. And I hope to hold off as long as possible. I've never been convinced that it's going to help me take better care of my patients. And I think one of the things that I see frequently, one of my most common complaints when I'm doing these reviews for OMIC is something Greg pointed out. I get reams and reams and reams and reams of paper to go through, and I'm looking for that little nugget that tells me what actually happened. But we get, 18 pages of the patient's past tests and drugs and et cetera, et cetera. Anyone who's gone into the hospital and looked through an OMIC chart, an EPIC chart, sees this all the time. So I don't have a medical a EMR. I do everything on paper, and thus far I've been very happy with that. We have another question here, Greg. Maybe you want to take from Dr. Adam.
We'll do that. I was just reading that. Thank you, Ron. The question is, I don't know if can everyone see this chat, these questions?
Might as well read it again real quick. Good summary.
Okay. Your comment on curbside consult within one practice was concerning. We do them all the time, which is very common in multi-subspecialty practices. That needs to change. For unhappy, I assume that's
below that. He corrected below that.
Yeah, encouraging a second opinion is a good idea. So we got a couple questions here. If so, better refer to a partner within the practice or out of the practice. Okay, first question, comment on curbside consults. Yes, do document them. And again, I mean, like Dr. Conahan just said, if all it is writing a note on a piece of paper that you can later scan into the chart, that's fine. But do something, because no one trusts their memory, and I could cite you very easily to many studies that would show your memory is not nearly as good as you think it is. Second part of the question has to do with referring unhappy patients for second opinions. I got to say, I do ophthalmology is probably about half, it's been half my trials. I do, of course, everything else from neurosurgery to gastroenterology. And the ophthalmologists, for whatever reason, particularly within the area of refractive surgery, are some of the most criticizing people. They will go after their colleagues hammer and tong. And so you do have to be careful with to whom you refer a patient for a second opinion. I think referring within your own practice isn't necessarily a great idea, but if you got nothing else, that's what you can do. My recommendation would be, if you know someone, it's not like your best buds, you golf together, you go to dinner parties together, that kind of thing. But someone that you know is not looking for a reason to undercut you and take your patients away, that would be the best recommendation I would have. So I hope that answered your question.
There's another question here from Dr. Shrestha, which is a common question being asked these days. Due to the COVID issue, how does using a virtual visit, telemedicine in other words, to check up on high-risk patients expose us to lawsuits when you can't see the eye very well, much less document? Greg, thoughts on that?
Wow, that's a really good and, of course, very timely question. That's the first COVID question I've gotten. But I would say that a virtual visit on a high-risk patient, well, I got some good news and I got some bad news for you. The bad news is that I think most people would probably say that examining someone via their iPhone, although I understand, isn't there an app now for ophthalmologists to check people via the iPhones? But in any event, if you've got a high-risk patient who's got a retinal issue, there's a good chance it won't be enough. By the same token, the good news is everybody loves doctors now. When I first started practicing 34 years ago, I would ask jurors, you know, have you ever had, before we start the trial, have you ever had a problem with a doc? You'd get maybe one or two people. Now, every single person on the jury panel has something to say about why they don't like doctors. That's all changed now because of COVID. So everybody loves doctors. They sit out on their porch and bang pots and pans at 8 o'clock every night. I do it to thank the doctors. So that's good. And in the end, what it comes down to, Dr. Shrestha, is that it's how the jury will perceive it. If you've got a good explanation for what you did and why you did it, I can probably defend it. I had 2 32 incision radiokeratotomy trials, which would probably make people who used to do that procedure cringe. And I defended them both because, number one, I had a doctor who happened to be a very, very, very good surgeon. Just his hands were amazing. And the other one is that he could articulate good reasons for what he did. And the jury found in both cases that was within the standard of care. So in answer to this very timely question, I think I probably could defend it because you would be exposing yourself, a patient who has I think now it's there. I saw a recent estimate that at least half the population has it, whether they know it or not. So you've got a probability of exposing yourself to a virus that could be fatal. And is what you did in response to that reasonable in the circumstance? If looking at them via the phone is pointless and you might as well be talking to them on a regular telephone, then that might not be enough. If what their problem is more symptom driven and as opposed to signs, I would say that probably would be enough because you're going to be relying on what they tell you anyway. But if you've got to do a dilated retinal fundus exam to see what their problem is, and it's a problem that you think may be progressing, wear a N95 mask, get a face shield and some PPE and suck it up.
I can tell you that the OMIC committee has dealt with this question several times here recently. And what we tell the ophthalmologist is that if what you're doing is for the right reasons, it's going to be a lot easier to defend. For example, if you are seeing a patient by telemedicine who has multiple morbidities or is maybe 94 years old, and you think that bringing him in is going to expose him to something that may kill him, maybe the medicine is the best you have to offer. And as opposed to, we've seen here in the last few weeks, LASIK surgeons who are advertising online, come get your COVID LASIK surgery when you've got some time off, and we'll give you a COVID discount, and et cetera, et cetera. And it's just a money grab. If what you're doing is to try to help the patient, and you think it's in the patient's best interest as you see it, that's going to be a lot easier to defend than if you were doing something that was just for monetary gain. So as Greg said, if you're doing a telemedicine and you can't see what you need to see, that may be a time, if you think the patient's going to lose vision, where you just have to suck it up and have them come in and be seen. Other questions?
So Dr. Pelton, it's Michelle. I get this question probably like 10 times a week in the last 2 weeks. And it's exactly like you say, there is still a duty to treat. And so if you have a patient that's high risk, it doesn't mean just because there's a COVID pandemic that you don't have a duty to treat. So we say the same thing. If you can, put on a mask, put on the PPE, and try to see the patient.
I'll point out too that OMIC in the last couple of days has put out an informed consent to use for telemedicine. It's something that you can send the patient by email, for example, and you can, or if you do something like a Zoom, you can read it together and ask them if they have any questions about it. And maybe they can sign it and mail it back in or scan it back in, or maybe you just get a verbal consent after they read it. But just know that if you go on the OMIC website now, you're going to find that there is a consent that you can use for telemedicine.
I have a question. By the same token, are we exposing ourselves to litigation risk by seeing patients during the COVID threat? In other words, if they come to our clinic and despite all of our best efforts to keep everything clean and so forth and so on, and check their temperature at the door and stuff like that, that they actually contract the disease in our clinic, even though we're only seeing like 4 patients a day, and those are just people that are coming in, because we want to be available for our patients and they've got legitimate reasons why they need to be seen that day. Are we exposing ourselves to any legal risk for that despite our best efforts if they were to contract the illness?
I don't think it would be possible, number one, to prove that they got it in your office. Number two, one of the things that I think I learned a long time ago is you can sue anybody for anything. You can sue the Pope for being Catholic. That doesn't mean that it's going to go anywhere or do anything, but I think it would be virtually impossible to prove that a patient that ended up getting this got it from your office. As Greg said, probably half the population has already been exposed to it or is carrying it right now. So that would be pretty low down on my worry list. You have a comment on that, Greg?
Yeah, I do, Ron, and Dr. Allen, that's a great question. Just keep in mind the plaintiff, in any case, that being the patient in this circumstance, has the burden of proof, and they have to prove more probable than not. And as Ron pointed out, I think it would be really hard for them to establish that they contracted COVID from any particular point source. Second thing is, it's a question of reasonableness. If you've taken reasonable efforts and you've got a patient who, as you've said, is high risk, risk of losing their vision, and you got a balance between, okay, exposing them to something that you've taken every precaution, through personal protective equipment to prevent transmission, that would be probably deemed as reasonable, and that you are trying to save this patient's vision. So again, what it comes down to is a balancing test. If the patient needs to be seen because, it's their annual exam, then no, don't do it. But if they're coming in because they have, they're diabetic, they've got, constant retinal problems and hemorrhages, and you need to monitor them regularly, then yeah, you need to. It's what it's been now, a month, I guess. And I'm sure you've got a lot of patients that you see every month. And so in circumstances like that, I think a jury would find in all probability that it was reasonable for you to examine them using appropriate precautions to prevent transmission. And then we got a comment here from Michelle. Thank you, Michelle. Just follow AAO, CDC, and State Department and Health recommendations regarding social distancing, PPE, and ask if they have a fever, et cetera. And I think, Dr. Allen, you mentioned a few things you can do. Take their temperature when they come in, do a questionnaire. Have you had any of the following symptoms? Although I've been talking to some doctors recently, emergency room doctors, who say they have patients who come in with upper respiratory, and they have patients who come in with GI complaints, and it's all due to COVID. So that's kind of a moving target. But again, what the gravamen here is what is reasonable in the circumstance.
Any parting questions for this evening? This is Chet Seward again. Okay, so process here. I'm going to send all of the contact information for folks that participated to OMIC, so you can get your participation for those discounts. Thank you again. And I'll jump on to what Greg said, especially today. Thank you all for being actively involved, not only in CSEPS, but in your profession and for what you're doing every day. It's a hard time. Stay healthy. And continue your service and your leadership. My contact information is on the screen there. Always happy to hear from you. Give me a call on that cell or text it. That's probably the best way. And then, I try to keep up with email, probably like all of you. If nothing else, I'll just bid you good night, and I hope to see you in person soon. Thanks again.
Thank you, everybody.
Thanks, Chet. Thanks, Ron. Good talking to you.
Good to see you.
Goodbye.
Thank you, guys.